Good morning and welcome to Gough Square Live, our live interactive seminar. My name is Richard Roberts, I'm with Michael Coley, and this morning we're going to be talking about company insolvency and administration and the effect that that can have on a prosecution of such a company. As always, the seminar is interactive, so if you have a Google account, please feel free to send us questions. You can also email questions, and we'll try and cover those at the end of the seminar. So without further ado, I'll hand over to Michael.
Thank you, Richard. So we're going to be talking today about a number of different procedures in insolvency, but also solvent ways that a company can bring its life to an end. And of course, these are going to have an impact on how and whether companies in those situations are prosecuted. So the first form of proceedings we're going to talk about today is liquidation, also known as winding up. And if we put slide 1 up just now, you'll be able to see some of the things we're going to cover. So you can see on slide 1, broadly speaking, there are two types of liquidation, compulsory and voluntary, and that's an important distinction for the purposes of today's talk. Voluntary liquidation has a further two subtypes, members and creditors voluntary liquidations. We'll discuss how stays on proceedings operate in liquidation cases. They both involve the appointment of a liquidator and then dissolution of the company, and we'll talk about what prosecution authorities can do in cases where liquidation is going on. So we can take slide 1 down for now. As we've just mentioned, compulsory versus voluntary liquidation. Well, voluntary liquidation generally doesn't require the input of the court, and it can often be done entirely administratively. It's compulsory liquidation, which results in court proceedings and is a bit more formal. The two types of voluntary liquidation are members' voluntary liquidation and creditors' voluntary liquidation. Generally speaking, the distinction between them is that a company doesn't need to be insolvent in order for a members' voluntary liquidation to take place. Insolvency generally just means that the company can't pay its bills or can't pay its debts. Members' voluntary liquidations generally take place where a company has served the purpose it was formed for or simply doesn't want to do business anymore. The members will meet up, will resolve to liquidate the company, a liquidator is appointed, and once that process is gone through, the company is dissolved. And that's often done for entirely legitimate purposes. Creditors' voluntary liquidation, again, in spite of the name, is often initiated by the members of the company. It's just like members' voluntary liquidation, but it's where the company is insolvent. And in those cases, the procedure can happen without the court having an input. There is no automatic stay on proceedings for a company that's in voluntary liquidation, but a creditor of a company in voluntary liquidation can apply for a stay to be imposed under Section 112 of the Insolvency Act. And if that is the case, then any proceedings against the company will be ousted by order of the court. By contrast, compulsory liquidation begins in court where one of the creditors of the company presents a petition to the court saying that the company cannot pay its debts and it wants the court to wind the company up. Now, in those cases, there is an automatic stay once the petition has been presented, and upon the hearing of it, the court has made what's called a winding up order. And the winding up order is simply an order by the court that the company should be liquidated, and it kicks the liquidation process into gear. Once that order is made, under Section 130 of the Insolvency Act, there is an automatic stay on any legal proceedings against the company, and that would include any criminal prosecutions. The next step in those cases is the appointment of a liquidator, and once the liquidator has liquidated the assets of the company and distributed it amongst the creditors, then he will give notice to the registrar of companies. Once that notice is registered, there are 3 months before the company is dissolved. It's at the point of dissolution that the company will finally cease to exist. And once a company ceases to exist, it has no legal personality and can't be party to any proceedings. So in cases of compulsory liquidation, there are a number of issues which really arise. First of all, knowing that the company is in fact in compulsory liquidation and there is a stay, because by continuing to proceed against a company with a stay against it, that you may be acting in contempt of court. So, what can you do if you wish to continue proceedings against a company in these circumstances? Well, the first thing that you can do is, if you know that the winding up petition is going to be presented, make representations at that hearing to oppose the making of the winding up order, and that will prevent the stay from being imposed in the first place. Although in those circumstances, Section 126 of the Insolvency Act still provides that creditors can nonetheless apply for a stay to be imposed even where the winding up order isn't yet made. The other thing that can be done is an application can be made to the court for the stay to be lifted for the purposes of the prosecution. So in those circumstances, the winding up order will still be made, but the prosecuting authority will have the permission of the court to continue the prosecution notwithstanding. And finally, the other course of action a prosecuting authority can take is that if there has been a winding up order and the liquidation process has been completed, during that 3-month process between the completion of the liquidation of the assets and the dissolution of the company, an application can be made to the registrar to defer dissolution, so that the company is kept in existence for longer than that 3-month period, which will allow the criminal proceedings to be continued and to be tied up if necessary. But the important things to remember when it comes to liquidation is to be aware at any stage whether there is a potential liquidation procedure, either compulsory or voluntary, and whether any stay applies, and what to do if there is such a stay in that case. So that's a very brief description of liquidation and how to deal with it. I'm going to turn you over to Richard now to deal with the next topic in the talk, which is administration.
Thank you. Yes, administration differs from insolvency fairly significantly. What this process does is allow the reorganisation of a company that's in difficulties or the realisation of assets of that company. And that happens under the protection of a statutory moratorium. The moratorium itself is provided for by statute. If I could have the first slide, please, on administration. This will set out some of the matters I'm going to cover. Now, the key thing about the moratorium is that it's supposed to be an interim or a temporary regime which provides a breathing space whilst the administrator seeks to achieve certain statutory purposes which are set out in the Insolvency Act. And the administrator will be an insolvency practitioner, in other words, an officer of the court appointed specifically to do this job. The 3 statutory objectives that the administrator is supposed to be achieving are set out on the slide there. Company rescue, a better result for the creditors than simply winding the company up, and distribution to secured or preferential creditors. So that's what the administrator will be working on. Now, whilst the administration is in progress, the question is what effect does that have on matters including prosecutions? And that's set out in Schedule B1's the Insolvency Act. And of particular significance in relation to the moratorium and the effect on prosecutions is subsection 6 of paragraph 43. And what that says is that no legal process may be instituted or continued against the company except with the consent of the administrator or with the permission of the court. So what that means, or on the face of it seems to mean, is that a prosecution cannot be commenced or continued without the leave of either the administrator or the court. And you can see at the bottom of the slide the case of Ray Wanda waste disposal is mentioned, and that dealt with this issue. Ray Wanda was a case involving a prosecution by the Environment Agency, wished to prosecute a waste disposal company which was just going into administration. And although it dealt with the provisions which were then in force, this is a 2001 case, sections 10 and 11 of the Insolvency Act, now replaced by the schedule I mentioned, Schedule B1, essentially the law is the same. It is that no legal proceedings can be commenced or continued without leave. And the question before the court, because there have been relatively few cases on this question, the first question that the court had to deal with is whether the term proceedings includes prosecution, and the court held that it does. So you do need the leave of the court or the permission of the administrator to continue your prosecution against such a company. The achievement of those statutory purposes, which were mentioned earlier on the slide, the court held that those could be hindered if prosecutions could simply go ahead without any potential for restraint. An ill-timed or an ill-thought-out prosecution, in the view of the court, could torpedo, in the words of the court, an administration order. It could prevent the realisation of assets and the continuation of the company. So for that reason, there has to be the potential for intervention. So if you as a prosecutor are bringing a prosecution against a company which is going into administration, then you will need the permission of the administrator or the court. And in the first instance, it's likely to be wise to write to the administrator and ask for permission. He or she may give it, in which case you can proceed with the prosecution. If that agreement is withheld, you will have to go to the court and make an application. And we'll come back later in this seminar to how those applications will be made. The court also dealt in Re Wanda with the factors that the court will look at in deciding whether to grant permission for you to continue your prosecution or to commence a prosecution when a company is in administration. And they include the kind of factors that you'd probably expect: the gravity of the offence, the history of the company's compliance with whatever the relevant regulatory standards or laws are, the level of risk that the company's activities present, whether there's been failure to comply with earlier enforcement action previous to the prosecution, and whether there's been any intentional obstruction by the company of investigation of its activities. So those are the kind of factors that will decide whether the court will allow you to continue your prosecution or whether the court will say that the moratorium is going to prevent you from doing so. And interestingly, although that was a 2001 case, there's been a more recent case in 2010, which was called Ray Frankis Golders Green Limited, and that held that this moratorium doesn't just prevent criminal prosecutions, it can also prevent other legal and even quasi-legal processes. That case involved the Gambling Commission, and they wanted to bring a couple of gaming companies before a review panel, a hearing or review panel, and it was held that the moratorium also affects those kinds of processes, and therefore again, either the consent of the administrator or the court will be required. So that is again a quick summary in this case of administration, and I think Michael is now going to carry on with insolvency.
Thank you. So we move from administration to the striking off procedure, and so we move now from the Insolvency Act to the Companies Act. Striking off is a relatively swift procedure, and as a result it's one that the prosecutors need to keep a very keen eye on because it can sometimes slip by in the course of proceedings. It doesn't necessarily require a company to be insolvent, but it's simply a way of dissolving the company and causing it to cease existing. So if we look at slide 3 now, you can see what the relevant issues are under the striking off regime. So you can see there are two ways that the regime can be initiated, either on the motion of the Registrar of Companies under Section 1000 of the Companies Act, and that's generally if the company is defunct. So if it hasn't filed accounts for a long period, the registrar can take steps to inquire whether the company is still operating, and if it appears that it's not, the registrar can strike it off the register himself. The second form is under Section 1003, and that's on an application on behalf of the company itself. But Sections 1004 and 1005 place restrictions on making that application. The procedure itself is relatively short and involves the publication simply of 2 notices. So we can take slide 3 down now. Where an application is made on behalf of the company to strike the company off the register, it is the striking off from the register which causes the dissolution. It can be a very swift process. It simply amounts to the company or company director filling out a form and submitting it to Companies House. That form contains a declaration that the procedure has been complied with, and that none of the restrictions in sections 1004 or 1005 apply. An important restriction is that no application can be made if the company has traded or carried on any activity in the last 3 months. And making a striking off application in contravention of the restrictions in sections 1004 and 1005 is in fact a criminal offence. However, assuming that the application is made properly, that will lead to the registrar simply publishing a first notice in the Gazette and on the Companies House website. All that notice says is an application to strike the company off has been received, and that if no further objections are received by any interested parties within the next 2 months, then the registrar will exercise the power to strike the company off. After 2 months have elapsed, the second notice is published, and the second notice simply says that the company has been struck off, and it's the publication of that notice which also serves to dissolve the company. Now, once that second notice has been published, the company is dissolved and will cease to exist. Now, this is a section which can often cause problems for prosecutors because it happens relatively quickly, and unless you're keeping an eye on Companies House and on the Gazette for those notifications, they can sometimes pass by without the prosecuting authority realising. Once the dissolution has taken place, that's it, the company's gone, and you're going to be wasting a lot of time and money continuing to investigate or continuing proceedings against a company, only to find out once you get to court later on that actually it no longer exists. And so that's why it's important to keep an eye on the procedure and make sure that you know, as with insolvency and as with administration, that you know whether there are any applications in the offing for striking off, just as there are in any proceedings relating to insolvency. We've talked a little bit in the course of slides 1 and 2 about the applications that a prosecutor can make to the court in cases where there are insolvency proceedings either through compulsory liquidation or in administration. And what we'll deal with now is Richard will tell you a little bit about how the procedure for making those applications works and what you need to do in order to bring them before the court.
Thank you. Yes, if I could have the fourth slide, please. You'll see from that the procedure for these kinds of applications is set out in Part 23 of the Civil Procedure Rules and the Practice Direction. But it is also important to look at the insolvency rules, which will also be relevant depending on the type of application that you're making. But broadly speaking, you will be making a Part 23 application, and you'll be making it in the court where the proceedings were started. And by the proceedings, I mean either the insolvency proceedings or the administration proceedings, the court in which that application was made or the order was made. So you will not be making an application in the Crown Court or the Magistrates' Court, notwithstanding the fact that you might be wanting to continue or commence a prosecution in one of those courts. You'll be bringing a civil application, and in the usual way, that will start with issuing an application notice. You'll have to prepare that and the necessary court fee, and most importantly for present purposes, a witness statement setting out why you want the order that you're seeking. And the matters that we've touched upon today principally involve seeking permission to continue or commence your prosecution. So your witness statement is going to want to cover the kind of matters that we discussed when looking at the case of Ray Wanda. In other words, the background to the matter, the history of the company, regulatory compliance, whether or not it's complied with the requests of investigators, the overall seriousness of the offence that's alleged, essentially the reasons why you wish to commence or continue a prosecution against a company that is going into an insolvency or an administration process. So you need to set that out in your application, file it at the court, and you'll also need to serve it on the other parties, the company, and you'd also want to include the administrator. And again, you'll need to look at the CPR, the Civil Procedure Rules, for the rules on service. So that in brief covers the applications, and I think Michael is now going to finish off.
Yes, so finally we move to the question of what happens if, in spite of your best efforts, the insolvency procedure or the striking off procedure has run its course, the company has in fact been dissolved and it no longer exists. Well, there is a potential procedure which can be followed to restore companies in that position to the register. And if we can look at slide 5 now, we can see what it is and how it works. So the procedure is under section 1029 of the Companies Act, and what it effectively amounts to is asking the court to effectively resurrect this defunct company, bring it back from the dead, and put it on the register of companies again, giving it legal standing once again, so that it can be a party to the prosecution. The procedure is relatively straightforward. It's a Part 8 claim form and a witness statement, which is usually issued either in the company's court or in the county court. And it's simply a statement saying that you wish the company to be restored to the register and the grounds for why you want that. It needs to be served on the official solicitor as well, because they are technically the respondent in the proceedings, although quite often those proceedings are not opposed by the official solicitor. However, in a case such as the ones we're dealing with today, where the prosecutor is not a director of the company, it may also be advantageous to serve on the director of the company as well. We can take slide 5 down now. If that procedure is successfully invoked, the effect of it is to put the previously dissolved company back into existence and back on the register. It can therefore be a party to the prosecution once again. However, it will lead to a few slight complications. For a start, it won't have any money. So while you can technically prosecute and convict it and have a conviction lying on the record against the company, it may be the case that it will be unable to pay any fine, for example, or any costs. And it's highly likely that if it was dissolved once before, it will probably be dissolved again fairly shortly after the criminal proceedings conclude. And so for this reason, it's very important when considering whether to exercise the section 1029 jurisdiction, or indeed when considering to exercise any of the powers to prevent a company from being dissolved before the fact, that you have regard to the public interest test and what exactly it is that you're seeking to achieve by preventing a company from being dissolved. If a company is genuinely insolvent, it is highly unlikely it will have any assets to pay a fine, and if it then is simply goes out of business, is dissolved and ceases to exist, will most likely not pose any further detriment to consumers. The directors, on the other hand, may still require some form of sanction, but of course liability for them is not going to be dependent on the fact that the company still exists or indeed is a party to the proceedings. So if you can make findings of fact about the company in the course of proceedings against the director, you may consider that the purposes of the prosecution are met. On the other hand, there is an important factor in deterrence, and it has been said in cases in the past, including the Ronda case, that in some cases a conviction against a company is important in showing that you cannot simply use the insolvency process to get out of your regulatory obligations and accounting for the breaches that you have committed. And so whether or not you decide to oppose a winding up or insolvency procedure, and whether or not you decide to try to bring back a dissolved company following its dissolution, will very much depend on those factors in the public interest test. The costs of undertaking those courses of action, and the regulatory sanctions that you hope to be able to achieve in the proceedings. Well, that brings the substantive parts of the talk to a close. I'll hand it to Richard, who's been monitoring the live chat and who's been looking at any questions that you've been sending in through there and by email. We'll see what you've got to say.
Thank you. We have a couple of questions by email. Firstly, can we just ask the Crown Court for an order that no steps be taken to wind up or dissolve the company or make it a condition of the director's bail that no such steps be taken. I think.
Well, I think that's going to be slightly problematical because, first of all, assuming that the Crown Court was prepared to make it, it would end up tying the hands of any court dealing with insolvency proceedings in the future. But also, it also ties the hands of the company director in relation to one of his key duties to the company. Now, if a company is genuinely insolvent, the director or any directors of the company are under a duty to commence insolvency proceedings at the point at which they either know or ought to have known that the company can no longer pay its debts. And if a director does not commence those proceedings at the appropriate time, he will be personally liable for any shortfall in the company's assets which occurs at the time that the insolvency proceedings are commenced. And any director who continues to trade with the company beyond the point at which he knew or ought to have known that insolvency proceedings should have been commenced will be committing wrongful trading. And so, because there is that obligation on the director, and also that potentially that quite onerous liability, personal liability, in financial terms, it's highly unlikely, I think, that that order would be considered an appropriate one by the Crown Court. It sounds like a nice shortcut, but unfortunately, I think the only way really to deal with the matter is to keep things under review, and to keep checking Companies House and the Gazette to keep apprised of any insolvency proceedings that may be in the offing.
Yeah. And secondly, is there a point in proceeding against a company which is in fact in insolvency?
Well, again, that's going to be very much a question of fact and degree. Sometimes that there simply won't be. If the company is going to be wound up, it's going to have no money to pay a fine. It will simply be off the scene, and the only meaningful sanction is against the director, who you can proceed against personally anyway. It may not be worth the cost and the time of proceeding against the company, and taking those extra steps to try to keep the company in existence in order to get a conviction, which will most likely become irrelevant once the company is dissolved shortly thereafter anyway. In other circumstances, if it's clear that the proceedings to try to wind up or strike off the company are simply a method of avoiding justice, and there is evidence of the director squirreling away the assets or doing something similar, it may be that there is a public interest in deterrence, in showing others that you can't simply abuse the civil jurisdiction in order to avoid sanction in the criminal jurisdiction. But it's going to depend on a huge range of factors, not only those ones in Ronda, but also the resources that it's going to take on the part of the prosecuting authority to actually bring those proceedings or become an interested party in the civil proceedings. And so whether there is a point in proceeding against a company in insolvency is going to depend very much on the specific factual instances of the case.
Yeah, it may be a case of an administration where the company is actually probably not headed for winding up. Administration can also lead to the realisation of assets, and the company can continue in some kind of shape in 12 months' time. So certainly in those kind of cases, there's no reason necessarily why you wouldn't want to commence the prosecution or continue it.
Absolutely, yes.
Yeah. And finally, will a voluntary liquidation require an application in the High Court?
No. Neither of the forms of voluntary liquidation, members or creditors, necessitate any application in the High Court or indeed any court. They can be done entirely administratively. Simply by resolution of the members, and thereafter it's all done through Companies House and the registrar. But that's one of the things which can make it very difficult sometimes for prosecutors to realise that they're actually going on.
Thank you very much. Thank you very much for the questions and for watching. I think that's all we have. So unless there's anything further we need to say.
I think the only other thing is that we are back on again in 2 weeks' time. For the next episode of Gough Square Live, and we also have a code to give you for CPPD, and the code is as follows. It's GSL RRMC28. That's GSL RRMC28 for your CPPD points. So thank you very much to everybody for watching and for all your questions. And join us again in 2 weeks' time for the next episode. Thank you.
Thank you.